Okay, we're there. Hey, everybody. Welcome to another episode of our live SQE show. And I have to tell you guys, today is a big day. And the reason why today is a big day, because today is SQE1 Results Day. So congratulations to everybody who has managed to navigate this process. And I'm not simply congratulating the people who succeeded. I am congratulating everybody because you've all put so much effort in. You all totally deserve it. So whether the result has been good and you guys succeeded, and it's all done, or whether you're just joining the system again because it didn't go as well as you thought, I just want to say well done. It is a very, very difficult thing to do. It is, in fact, something that I've been complaining about for ages. So many of our colleagues and our candidates are going through this, and it is really a very difficult and challenging process. So I think you should congratulate yourselves for having been through it, for having gone through the expense and the trouble and the difficulty and having come out the other end. I know that some of you will be celebrating today because you got the results that you wanted. Some of you are going to be very disappointed. If it hasn't gone well, please remember that this is not the end of the world. You have opportunities for resets. I know that, sometimes these things go well and sometimes they don't. We will be here to support you. And be sure to sort of reach out. If it didn't go particularly well today, be sure to reach out in your family, in your community, in your friends. Go out, have a drink, try and do something. Just don't dwell on it. And I know quite a lot of people who have had the horrible disappointment of not getting the result that they wanted, and then having the joy of having passed it the next time they tried it. So we're going to have the opportunity. We're going to do like a student hangout in the next few weeks. So we're going to have an opportunity to talk about it and to talk about how do you deal if you didn't pass and what you do next and what are appropriate steps and to support the people who are in that situation. So just to recap, congratulations to those of you who are receiving your results today. We'll see. I'm waiting for the feedback statistics from the SRA to see whether I was proven right in my prediction. What was my prediction? My prediction was that the results are going to stay at the same level that they were before, that we're not going to have another drop. Because if you remember when we were discussing this last time, in the summer, the results dropped quite significantly. So the pass rates were fairly low, and everybody was waiting to see what's going to be the experience in January. My result of the analysis from the statistics and so on was that in January, it's going to get better, that we're going to go back to kind of between 50 and 52, 55% success rate. So I'm waiting for the SRA statistics to see what actually happened there. Okay, so the rest of you, because there are more people in here, the rest of you looking forward to the July exam. How are you guys getting on? So send us a message if you're watching this live, or if you're not watching live, remember to put a comment down in the box so we can have a discussion, and let me know how you guys are getting on for your July preparation, because now we are already in the middle of March, so we are getting close to it. So as I said, the more we can do, the better it gets, right? So the more prep, the more connection, the more discussions with the community, the more friends we can find to kind of hang around with, the more we're engaged in the process, the more likely it is that we're going to do well. So let me try and share my screen for our usual slides. Where are the slides? Hang on. I have pressed the wrong thing here. Let me see. So what I want to do is this, share screen. Let's see, I managed to do this every time. All right, so normally you should have the screen popping up. And now I should have dropped down to the right-hand side of the screen as a little thumbnail. All right, cool. Okay. Right. First of all, did you guys know that we had a giveaway? Yes, we had a giveaway. So congratulations to the gentleman that won the first set of books. So I am clearing up everything. I'm cleaning up the house. I'm cleaning up the office. I'm cleaning up everything that I've got, and I'm discovering boxes full of SQE relevant books. These are not the latest ones. Be mindful of that. These are the books that I used like 3-4 years ago to prepare myself for the SQE, when I was writing material, when I was investigating what's going on, and I was trying to get like a good feel of how one prepares and where the material are, and also to review all the books and all the resources. So I've ended up with a few bags of SQE relevant books. So one of them was running as a giveaway for our newsletter subscribers and everybody who wanted to subscribe to the newsletter. The newsletter, by the way, is at newsletter@glintis.co.uk. You can look around the description and the comments, and you're going to find the link to this. So this is the newsletter that I'm sending every Monday. And you know how many I've sent already? 78. Yesterday, I sent newsletter number 78. So I've been doing this for 78 weeks straight. What does that tell you guys if it doesn't say commitment? Yes, 78 weeks of SQE1 MCQ newsletters with MCQs for you guys to train, with reading material to study, with discount codes so you can get discounts on your books and in your online support and all of that stuff. Tips, tricks, and everything else I can think of. So it's been going on for 78 weeks. So if you guys want to keep it going to 100, be sure to subscribe. So what I did is I offered the giveaway of my first batch of SQE books for people who wanted them, who are in London and they can physically pick them up. So we have a winner on that one. So congratulations. And I've got a couple more bags, because as I was emptying more boxes, I discovered more bags. Yeah. So I've got 2 more batches. These have been made available to our channel members. Now, you're probably a subscriber to the channel, so thank you very much for this. In addition, you can become a channel member. What this means is that you click the join button and you pay $2.99 a month to YouTube, and then YouTube gives me some of that and I can buy myself a coffee. So for $2.99 a month, you can be a paid member beyond being a subscriber to the channel. Then you get various freebies that I've got coming up. You get to see all the videos I've got scheduled, because I've got a stack of videos going all the way into the summer. If you're a channel member, you can see all of those straight away. And then you get to participate in the private Facebook group we've got that I call incomprehensibly Iglinavos Scholars, right? And then we can talk about your preparation over there. So the first batch of books went to this gentleman here, who's a subscriber to the newsletter. The other 2 sets of books have been given to members of the channel that were available to come and pick them up in London. So hopefully you guys are going to find all this stuff helpful. If you don't, you're free to sell them on eBay. I don't mind. I'm giving them away for free. Right. So with that stuff out of the way, shall we do some questions? Shall we? Are we ready? So the topic today is a little bit different from the stuff that we do, because we've done already. So this is number 9 in our weekly live streams for SQE Prep. So we've done some on contract law, we've done some of business law, we've done some on dispute resolution, and a few other topics in between. Now we're dealing specifically with constitutional, admin, EU law, and human rights, because this is also part of what you guys need to prepare for the SQE, and perhaps it is not something that gets foregrounded in your preparation. So I thought it might be a good idea to put these last 2 sessions, so session 9 and session 10, to put them on those topics. Now, in case you guys are getting addicted to me every week, normally on a Wednesday, today we're doing it on a Tuesday because tomorrow I'm teaching a webinar all day. Now, if you're becoming fans of this show and you're watching it on a weekly basis, once we finish this set of classes, which is, the 10 webinars that I described, I'm not going to leave you guys hanging. We're going to do the occasional student hangout. So this might not necessarily be on a weekly basis. We can kind of space them out. and we can do student hangouts or candidate handouts with different focus. We can talk of some of them about SQE, we can talk about prep, we can talk about the law, we can talk about structured study at different points in time. So I've already had a couple of those hangouts and they went really well, and they also contain some of my students from the institutions that I'm currently working on. So it's a good idea to meet new people. So I think these are fun. So we're going to do those. And then we are going to return after the summer when people are beginning again their SQE prep. We're going to return to another schedule of weekly SQE prep, MCQ-based live streams to help the people who are now working towards the January 2026 examination. So everything that we're doing now is focused towards the July 25 examination, but it's going to come back again. So, the SQE is the gift that keeps on giving. So we're going to be doing another set of sessions for this in the autumn term, going towards the January exam. So hopefully you won't be back, because if you're preparing for the July, you have done this successfully, and then you don't want to do this again and you finished with SQE1, right? But if we've got people here who are looking forward to the January 26 examinations, you're going to have the chance to participate again in a set of these classes going forward from January, from September, looking towards January. Okay, good. Are we doing all right so far? If you guys are happy with this and it's going well, give me a thumbs up so I can tell that you guys are happy with it. And if you're watching this on the replay, again, hit the like button so this gets the spread to more people, and write a comment down in the comments box to let me know how you feel about those sessions, right? Okie dokie. So let's start with scenario 1. Today, as I said, we're dealing with constitutional, administrative, and EU law. All right. Scenario 1. The UK government proposes a new law that would place significant restrictions on the right to peaceful protest, including the power for police to ban protests that are deemed to cause serious inconvenience to the public. Several human rights organizations argue that the proposed law is unconstitutional because it undermines fundamental democratic freedoms. The government insists that Parliament has the authority to pass the law without restrictions, while critics argue that it violates constitutional principles and the rule of law. A very topical issue these days, right? So, which of the following best describes the constitutional principles that may be relevant in determining the legality of the proposed law? Is it A, the rule of law and parliamentary sovereignty? While Parliament has the power to make any law, the courts may assess whether the law conflicts with fundamental constitutional principles. Is it B, separation of powers and the royal prerogative? The courts can block any law passed by Parliament if it is contrary to democratic freedoms as part of their constitutional oversight. Is it C, judicial supremacy and the written constitution? The UK courts have the power to strike down laws that violate constitutional rights, similar to the US Supreme Court. Is it D, devolution and parliamentary privilege? The law must be approved by devolved governments before it can apply across the UK. Or is it E, common law and statutory supremacy? Common law principles automatically override any statute that conflicts with fundamental rights. So our question was, which of the following best describes the constitutional principles that may be relevant in determining the legality of the government's proposed legislation? I can see we've got some people watching us live here. Would you guys like to venture an answer? Is it A? Is it B? Is it C? Is it D? Or is it E? Aha. Wait for it. The answer here is A. The correct answer is the rule of law and parliamentary sovereignty. While Parliament has the power to make any law, the courts may assess whether the law conflicts with fundamental constitutional principles. All right. Now, what do we know? What are the basic characteristics of the British Constitution? Everybody knows that the UK has an uncodified constitution, meaning that the constitutional principles are based on statutes, the common law, and constitutional conventions. It does not have a single written down set of rules, so it does not have a written constitution. There are two key principles in British constitutional law. The first one is parliamentary sovereignty. This means that the parliament has the supreme authority to make or unmake any law. And if you want some kind of background theory going back to the Victorian era, you can look at Dicey and his theory on parliamentary sovereignty. The idea is that the courts have the capacity to judge what the parliament is doing, but the parliament remains the supreme authority in creating the law. But we have also the concept of the rule of law, that is the second key constitutional principle. So under the Constitution, laws must be fair, clear, and respect fundamental rights. Now, the courts do have a role in interpreting legislation in line with constitutional principles. And specifically since 1998, where we had the introduction of the Human Rights Act, we have particular human rights protections that have become fundamental within the Constitution. So the courts are using their function of judicial review to assess whether executive actions and the laws themselves are proportionate and lawful. Right, so let's see why the rest are incorrect. B is saying that the courts can block any law passed by Parliament. Not quite. I mean, since Parliament is sovereign, the courts do not have an overarching ability to strike down laws, but they can assess the validity of the law on the basis of the overall position of the Constitution. So B is not correct because it's a bit misleading. Now, also C is incorrect because the UK courts do not have the powers that the US Supreme Court has, for instance, to annul legislation. Now, the closest that we come to it is through the interpretation of the European Convention of Human Rights and how it's embedded in the Human Rights Act. But I think it is a risky business to equate the way the Supreme Court operates with the US Supreme Court. Option D is incorrect because it talks about devolution. Devolution does not affect UK-wide parliamentary authority. And option E is incorrect because the statutes do take precedence over the common law. So the overall conclusion is that the parliament has the power to pass any law, but the courts play a role in ensuring that government actions comply with the rule of law and respect fundamental human rights protections. Now, is this a good arrangement or not? Well, not particularly, because not having a written constitution leaves a lot of things to be determined later on, and also causes a great degree of anxiety and the potential for conflict when things are not clear-cut. And we always thought, because I've been studying that stuff ever since I was a student, right? So I started studying law in this country like in the mid-90s. So even then, we were saying that there is such a good understanding of constitutional principles and such robust history and expectation of behavior on the part of state institutions that even though this is an uncodified constitution, it is unlikely that we're going to get into positions of difficulty. And my teachers used to say at the time that Europe tends to have written constitutions because it has experienced unrest and political conflict and conflicts within institutions in more recent history, and that's why they felt that they needed a written constitution to sort of nail down expectations. But this has been less problematic in the UK, and that's why the UK system is more flexible and operates on the basis of consensus. Now, all of that showed that it didn't work particularly well in the Brexit situation. Because when Theresa May and her government tried to implement the Brexit referendum, we ended up in a lot of unknown things. Because this was a fundamental change in the way the law was operating and a fundamental change in constitutional norms. The government wasn't sure what to do, Parliament wasn't sure what to do, the courts were not sure what to do. And when they needed to prioritize different objectives, how do you deal with sort of democratic mandates against protection of human rights, they ran into trouble, and there's been a lot of cases in the Supreme Court trying to explain these concepts, which demonstrated, at least to me at the time, that an uncodified constitution leads to trouble in cases of pressure and crisis. So it's always great to say that the system is fantastic and is flexible, where nothing bad happens and everything works well. Great, okay? But the whole purpose of constitutions is to protect you against things going bad. It's to provide guidelines in situations of crisis. So when the UK found itself in a situation of crisis, the uncodified constitution was a hindrance rather than a positive element in the way that the law is structured. Now, you can compare this to what's happening in the United States at the moment, right? Because the United States is going through a political upheaval and potentially constitutional crisis if it turns out that the institutions of the state begin to behave in ways that are unanticipated. For instance, in the US, they've got a very rigid distinction between who does what. So the executive has certain powers, but the legislature has the power to raise taxes and raise money and make certain decisions. And then the courts have got the power to control all of this in the way that it is behaving. But if the presidency assumes for itself the right to generate money and to raise revenue, for instance, through tariffs instead of taxes, that blurs the distinction between what the legislature is authorized to do and what the government is allowed to do. Then, if the courts become very politicized and either refuse to hold the government into account when it seems to be breaching the law, or alternatively, the government refuses to respect the position of the courts when the courts make decisions that it's breaching the law, then you've got flex and you got movement in the way that the institutions are behaving and they understand their roles. Question: will the US Constitution, being a codified constitution, fare better in times of constitutional crisis than the British Constitution did during its period of crisis during Brexit? I don't know. We will see. It's possible that neither of them works particularly well in intensely political and conflictual situations, but we will see. The base assumption is that written constitutions are more resilient in times of political crisis, where uncodified ones are dangerous. Okay, the UK survived. We will see what happens in the US, and then scholars will have the opportunity to write about this. But, I do appreciate that while this might be very interesting and it's happening in the world around us, it is not necessarily relevant for the SQE. For that reason, we are going to move on and look at our scenario 2. Yes. So when we have our hangouts where the themes are a little bit more loose, then we can talk about what's happening in the world in a little bit more detail. But I'm trying to keep this particular stream focus on the SQE for your SQE prep. Alrighty, now scenario 2. Lisa applies for a government business grant from the Department for Economic Development. The department's published policy states that grants are available to all small businesses that meet specific financial and operational criteria. Lisa meets all the requirements, but her application is rejected without explanation. She later learns that the department approved grants for other businesses with identical qualifications and suspects that her rejection was arbitrary and unfair. Lisa wants to challenge the decision through judicial review. Right. Question: which of the following grounds for judicial review is most relevant to Lisa's case? Is it A, irrationality, what's sometimes called as Wensbury unreasonableness? The decision is invalid because Lisa personally disagrees with it. Is it B, procedural impropriety? The department may have failed to follow fair decision-making procedures, such as giving Lisa reasons for her rejection. Is it C, illegality? Judicial review cannot apply here because government decisions cannot be challenged in court. Is it D, separation of powers? Courts cannot interfere with government decisions as only Parliament has the power to review executive actions. Or is it finally E, proportionality? Lisa must show that the decision was excessive in relation to the policy objectives of the government grant scheme. All right. Let's have a think. Which one, we have some people watching us live. Thank you, guys. Which one do we think it is? Right. Let's see. I will give you the answer in 3, 2, 1. If I manage to find the right sheet, that is, I'll give you the answer. The correct answer is B, procedural impropriety. The department may have failed to follow their decision-making procedures, such as giving Lisa reasons for her rejection. Okay. Now, what's the explanation for all of this? What is judicial review about? Judicial review is a process that allows individuals to challenge decisions made by public bodies if they're made unlawfully or unfairly or unreasonably. So there are three main grounds for judicial review. The first one is illegality. A public authority acts beyond its legislative powers, as we say in Latin, ultra vires. Secondly, we got procedural impropriety. Here, the decision maker fails to follow proper procedures. For example, it could be that they're obligated to give reasons for their decision, and they have failed to do this. 3 is irrationality, which goes to what I said is Wensbury unreasonableness. The decision here is so unreasonable that no reasonable authority could have made it. If you want to see the background for this, you can look at the case of Associated Provincial Picture Houses versus Wensbury Corporation from 1948. So clearly, there needs to be some check for kind of reasonableness on the way that public authorities are making decisions. Now, which one is the most appropriate in Lisa's case? What we're dealing with here is procedural impropriety, because the department has failed to give reasons for rejecting Lisa's application. And if it is true that we have identical businesses that received grants while Lisa did not, then that implies that there might be a lack of fairness or consistency in the decision making. So the government bodies are obligated to follow their own publicized procedures, and they're obligated to act transparently in relation to the public. This is key in maintaining accountability and demonstrating respect for the rules. Otherwise, you're getting into a situation that decision makers can do whatever they want, and this can be hugely problematic. Imagine, for instance, in the context of public procurement, if you've got a bunch of suppliers that are applying for government grants, and then the government grants are given willy-nilly because the decision makers do not respect their own process, it can be hugely damaging both in economic terms and also in competition terms, but also in creating a sense of unfairness and impropriety in the operation of the state. I mean, how would you feel if, say, you were applying for something or for work, or there's like a promotion or something and they published specific criteria, but then somebody else got promoted instead of you, and when you asked for feedback, they gave you a list of completely different criteria that were not mentioned before, or they even refused to give you any answer and they just said, we like the other person more than you. So obviously you would be upset. This isn't just a matter of being upset. This is a matter of not respecting the rules, which makes it a legal violation. Therefore, Lisa does have a right to complain, and the process for judicial review is precisely there to give Lisa and people in her position the tools to challenge the decision-making of public authorities. So the correct option is option B, right? So why are the others incorrect? Option A, that was about irrationality, is incorrect because we don't actually have any evidence that the decision was irrational. We don't have any evidence at all. C, about illegality, again, is incorrect because we're not talking about this at the moment. We don't know whether they violated legal requirements, but we do know that they haven't followed their own procedures. The option about separation of powers is not relevant to what we're discussing here, and the option on proportionality, while important, is not correct with what's happening here. Okay, so correct answer B, and everybody in that position will have the opportunity to apply for judicial review. So remember, we're talking about administrative law here, and judicial review is the tool that the citizen has in using the administrative law processes to challenge or test that the decision-making of state authorities is done in accordance with the law and published procedure. In real life, you will come across this frequently, where people are challenging council decisions on planning permissions. This is something that happens in the UK very frequently, because you need permission to build stuff or extend your house or whatever. And if the local council, has got specific processes for this, if they reject your application and you don't think that they have followed their own rules, then the tool available to you is to bring it to the courts for judicial review to check the process that the council has followed. So in a way, you're not saying I should have had it because I'm great and my application is fantastic. No, you're saying that you have not evaluated my application properly. I'm not saying that I deserve to have it. I'm saying that I deserve to be assessed with the same standards as everybody else. All right, cool. So if this makes sense to you guys and you're enjoying this, hit the like button so I know that you're still watching me and you have not fallen asleep. So we got some people watching live, which is amazing. Coolio. So let's move on to question number 3. Okay, question number 3. So we've got our friend James. Guess which cup of coffee? What's the number? What number cup of coffee is this? I know that I had told you a few weeks ago that I was making an effort in consuming less coffee. I have failed. So I think this is already coffee cup number 5 for the day, and so it's only noon. So it's definitely not good. So if you don't see me in the future tutorials, you probably will have figured that my head has exploded. Right, okay, James. Let's see what James is up to. Righty. Okay. Oh, James is a UK-based business owner. He imports and sells electronic goods from Europe. Following Brexit, he assumes that European Union law is no longer applicable to the UK and does not need to comply with EU product safety regulations. However, the regulator informs him that certain EU-derived legal standards are still binding in the UK. James is confused by this because, he watches a lot of TV and that's not what they told him. He seeks legal advice on the continuing role or not of EU law in English law post-Brexit. Now, the question for you guys: which of the following best explains the continuing importance of EU law in English law after Brexit? Is it A, all EU law ceased to apply in the UK immediately on Brexit Day, meaning James has no obligation to follow EU rules? Is it B, UK courts must still follow decisions of the European Court of Justice in all legal matters as EU law remains supreme? Is it C, EU law only applies to businesses that trade directly with the EU and UK domestic businesses are not affected? Is it D, Parliament has no power to repeal EU law in the UK as Brexit agreements permanently incorporated all EU laws into English law? Or is it finally E, retained EU law remains part of UK law, meaning that certain EU-derived regulations still apply unless and until changed by Parliament? Aha! Alrighty. What do you think? Is it A? Is it B? Is it C? Is it D? Or is it E? Okay. You can put your money where your mouth is and also give us a super chat while you're giving your answer. So the way that you can do this, so if you guys are not content in becoming channel members and paying YouTube, rather, because I don't get this, paying YouTube $2.99 a month to support me, you can also show support to Dr. Yannis, as it says there, by clicking the next to the chat. It's got something that looks like a dollar note. If you click the dollar note, then you can send me a super sticker or you can send me a super chat and choose the amount of money that you're sending over to show your support to my efforts being here yelling about Brexit and EU law. So, thank you. You don't have to do it, but, thank you very much if you're considering this. Alrighty, let's go back to what happened with EU law. The correct answer here is E, number 5. Retained EU law remains part of UK law, meaning that certain EU-derived regulations still apply unless or until changed by Parliament. Okie dokie. Now, why is all this? The UK technically left the EU at the end of 2020. However, EU law was very much embedded in the UK legal system. And so far as English law is concerned, for those of us taking the SUE, EU law remains a significant part. So they couldn't, it would not have been a great idea to automatically cancel and extricate the totality of EU law from the English legal system on the 1st of February 2020, whatever it was, right? It would not really have worked because the two systems were working alongside each other, and EU law was informing what happens in English law for decades now. So it would have caused mayhem if all the legislation was kind of automatically extracted and we went back to the rules as we had them in the 1980s or before that, right, in the 1970s. So the European Withdrawal Act of 2018 effectively froze in ice, froze in time, EU law as it existed at the time of withdrawal. So it's interesting that the UK now runs a historical version of EU law. So it is no longer following the evolution of EU law. So after anything that happened post the creation of EU law, post the withdrawal, any new rules that came in, any new decisions of the Court of Justice, anything that's been happening from that point onwards has deviated. So now there are two different paths, two different versions of EU law. One is the live, real EU law that keeps progressing in the directions that the member states and the Court of Justice want to take it. And the other one is the historical bubble of EU law as it existed at the time of the British withdrawal. The withdrawal agreement retains that historical version of EU law and incorporates it into the British legal system. So that continues to operate without a disruption in norms and processes, which would not have been a good idea, but it no longer follows the evolution in Europe. So the systems have detached. So English law now contains within it, like a kind of EU baby that is not growing anymore, but stays at the age that it was when the withdrawal agreement happened. And of course, the idea is that after Brexit, the UK has the opportunity, if it wishes to do so, to deviate from EU law. So slowly, there might be a degree of deviation from EU law rules, norms, and standards. But that is happening in an incremental fashion whenever Parliament gets around to it or it discovers that there is something that needs changing. Now, okay, fair enough. Now, what this means is that we have the concept of retained EU law. We've got this kind of historical bubble within it exists. And the impact for business is that clearly you cannot forget anything that was EU origin that became part of English law in the last 40, 50 years. Yeah. So this continues to exist and continues to have importance, but it might in fact be different from what is applicable now in the EU. If you want an easy example of the sort of stuff that came into English law from an EU direction, all the consumer protection stuff. So what we've got in the Consumer Rights Act of 2015 is very much builds upon the consumer rights regulations that were created in the EU. So a great deal of our understanding of consumer rights, protection against unfair terms, and all of these things are EU law at base, and they slowly became incorporated into the UK system. So if they had taken the view to sort of extricate everything, then we wouldn't be able to operate things like the Consumer Rights Act and a bunch of other stuff, so it would have been hugely problematic. So the other options that we've got here are incorrect for the following reasons. Option A says that all EU law became, ceased to apply immediately. This is wrong. This is not what happened. Option B says that UK courts must still follow European Court of Justice rulings. No, they don't. Okay. Of course, the interpretation of the rules by the European Court of Justice for the retained part of EU law will still inform the decisions of British courts, but they no longer have to follow the jurisprudence of the European Court of Justice. So not only the historical version, like the EU law baby that exists within EU law, doesn't grow anymore, but it could actually be interpreted in deviant ways from what's happening in Europe. Option C says that EU law only applies to businesses trading with the EU. Well, this is technically incorrect. However, it has a level of truth to it for the following reasons. If you're doing business in another jurisdiction, you need to be mindful of the regulatory and legal requirement in that other jurisdiction, because that will lead to trouble. So if your customer, if you want an easy example, if your customer is in the EU, you need to be mindful of GDPR. So data protection and privacy and the handling of data, because jurisdiction for that one depends on who is the user, who is the person that gave you the data, not who is the one controlling them. So even though you're a British corporation subject to British law, if you're handling data of EU customers, you got to be compliant with the EU version of GDPR as well as UK GDPR. And for other things, trade in goods, for instance, safety standards, etc., you cannot ignore European or American safety standards if you're producing here, because you're trying to sell it there. Because if you just comply with your own standards and your standards are different from theirs, they might refuse you the right to sell it over there. So the reality of business is that even though you're sort of governed and examined on the basis of domestic law, if you want to have access to markets that are over there, you need to be sure that you're compliant with the requirements of those markets. So it's a very easy thing to understand, because it's an essential part of business. Now, to finish this off, option D was also incorrect, because the Parliament has no power to repeal EU law. They can change the retained EU law, okay? But, they have no power to change theirs, but they can change the one that is retained, like the EU baby that exists within, right? So it sort of kind of misrepresents what the Parliament is able or not able to do. Okay, and in fact, since it is incorporated within, they have the right to change that. They cannot change the European one, but they can change their own. But changing their own does not have external effects. All right, so hopefully this gives us some clarity on what happened with Brexit and with EU law. Now, it gets a little bit more complicated than this if we're talking about human rights, but also remember that very often discussions about human rights, they're not talking about EU law and the European Court of Justice. They're talking about the European Convention of Human Rights and the European Court of Human Rights. These are separate institutions. There's a great deal of confusion both amongst the general population and in students and candidates for the SQE between those two. We could be talking about human rights obligations in domestic law, we could be talking about human rights obligations in EU law, or we could be talking about treaty-based human rights obligations that are coming from the European Convention on Human Rights. All these are different domains. So be sure that if you're answering a question that contains something about human rights, you don't get confused amongst those different domains. If any of the politicians are watching this live stream, they will have, now they know about it too, so they don't get it wrong when they go on the media and talk about this. Okay, are we ready for our next question? Yes, give us an emoji. I've got people watching this live. You guys are very quiet. Give us an emoji if you're liking this. Or, if you're watching this on the replay, give us like a thumbs up or write something in the chat. Let's make this an interactive experience. Okay, now what else do we have? Scenario 4. Since we were talking about human rights, let's talk about human rights. What do we have here? Tom is arrested. He's arrested by the police on suspicion of theft. He's taken into the police station where he's denied access to a solicitor, and they hold him in a cell for 24 hours without informing him of the charges against him. He is finally brought in front of a magistrate, and he argues that his human rights have been violated. He seeks legal advice on whether he can challenge the actions of the police under the Human Rights Act of 1998. Question: which of the following rights under the Human Rights Act is most relevant to Tom's situation? So look, we're talking about the domestic human rights legislation here, not the EU one, not the conventional one, the domestic one. Are we talking about the right to respect private and family life? Or are we talking about a right to liberty and security? Are we talking perhaps about freedom of expression? Or are we talking about protection of property? Finally, are we talking about the prohibition of torture and inhuman treatment? Because, they kept him there for 24 hours. So which one are we talking about? Now, the Human Rights Act incorporates into UK domestic law the European Convention of Human Rights. But since it is a domestic piece of legislation, then the UK courts are responsible for the implementation of those rules. In doing this, the British courts are taking guidance from the European Court of Human Rights, which is the special court that exists for the convention, right? But in order of primacy of rules, the English courts are still primary in making determinations on whether something is okay or not under the UK Human Rights Act of 1998. Again, there is some opportunity for confusion between the different kind of streams of law and the operation of the various courts. But in this context, we're thinking about its domestic application. Now, the Human Rights Act reflects in English law all these rights that are coming from the convention. The right to respect people's private and family life, the right for people to liberty and security, freedom of expression, the protection and enjoyment of their property, and of course the prohibition from gross human rights violations such as torture and inhuman treatment. Here, Tom has been arrested. So the problem is right to liberty and security. He has been detained by the police and they have not informed him of the rights upon arrest. Now, I've got a video coming up on precisely what are your rights upon arrest. Hopefully you don't get to use this yourselves, right? But you might get to use it as solicitors if you're advising a client who's been arrested. So this is currently one of the videos that are scheduled to appear later. If you're channel members, you can watch it straight away. If you're not channel members, it's going to appear and you guys can watch it a bit later on for free. I'm going to put the link down in the description so you guys can see what this is about. So there are a series of obligations that the authorities have towards somebody who's been arrested. There are time limits as to how they can hold them and when they need to release them. There's also quite a lot of information as to the sort of communications that an arrested person can have with the outside world and what the police needs to tell them and whether they have to cooperate with the police or not. So having a look at this, I've got additional videos on criminal law and criminal procedure that kind of feed into this as well. The answer in the context of this question, the correct answer is B, the right to liberty and security. And the problem is that he has been detained without information. So one of the key provisions of the Human Rights Act that has to do with liberty and security is aimed to protect people from arbitrary detention. So anybody who is arrested by the authorities must be promptly informed of the reasons for their arrest and to be given access to legal representation. So here, the police's failure to inform Tom of the charges is a denial of legal access. So therefore, this might be a violation of the provisions of the Human Rights Act. Now, the others are incorrect because they're talking about slightly different issues. So the problem here is not the violation of his privacy, as you have in A. It's not about his freedom of expression, as in C. It's not about protection of property. He's been arrested for theft, but it's not his property being taken away. So that's incorrect. And Now, E is incorrect because detention by itself does not meet the threshold for inhuman and degrading treatment. It's not like they threw him in a jail cell for months, okay? So it's just 24 hours, so it wouldn't actually be considered that bad to reach the level of torture and inhuman treatment in and of itself. Now, if they mistreated him while they have him detained, that would be something else. So the correct answer here is in Article 5. So I don't know the extent to which you guys intended to spend a great deal of time on the constitutional, administrative, and human rights law parts, but be mindful that these are very much part of the syllabus that you bring examined. So these are very much present in the FLK. Because they're present in the FLK, I've got specific videos on these categories, because now on my channel, I've got two specific playlists. One is covering FLK1, and I've got a video for every topic in FLK1. The other one is covering FLK2, and again, I've got a video for every topic. So if you go to the homepage of my channel, you're going to find towards the bottom these two playlists that are clearly marked as FLK1 and FLK2, and they've got a video for each aspect of the syllabus of what you need to cover. Now, I'm concerned that because these look a little bit off people's everyday experience. People are either doing civil commercial law or they're doing criminal law. Not many people are going into these directions for the constitutional stuff. It might be missed out. And if you're missing something out big time, then if you hit questions like this in the exam, you might be unprepared for it. So that's why I wanted to devote the last two sessions that we've got in this list of live streams to talk about constitutional, administrative, EU law, and human rights, to make sure that everybody's up to speed with these. So thank you very much, guys, for tuning in today. It's been great to have you. It's been great to have some people watching us live. For the rest of you watching on the replay, please drop me a note to let me know whether you're enjoying the stream or not, if you got any additional questions, and I will communicate with the rest of you guys either through the general public Facebook group that we've got or through the members-only Facebook group. So again, thank you so much for turning up this Tuesday. Next week, we're meeting back on our normal slot on Wednesday, I believe. So I'll see you guys soon, and have a nice day for the rest of your day. Thank you, and see you. Bye.